Carryover re-referral while we're waiting for Chairman Nicholas to get here. We know that everybody's got a lot on their plate, and so we'll try and accommodate, try and get everything through us first. So, Mary Lee, why don't we go ahead and do roll call? And then we're going to start with House Bill 109 on that re-referral.
Representative Kinner.
Here.
Representative Larson.
Here.
Representative Schwartz. Here. Representative Simpson.
Here.
Representative Stith.
Here.
Representative Walters.
Here.
And we're waiting on the chairman.
Okay, we've got House Bill 109. Do we have anybody here? Jenny, any of the representatives here? Committee, what they do on this is they put 70,000 in for a study by section 1. You've looked at this. You have. Is there a motion? Representative Walters.
Mr. Chairman, I would move the bill. Second.
Okay, bill's been moved. Any public comment on this bill before we address it? Committee, what's your pleasure?
Question on the bill.
Okay. Who else is that? So when we say public comment, you got to let us know. Can't read your minds.
No, I'm just gonna pull it up.
Please proceed.
I am, Mr. Chairman, I'm Dave Davis. I'm the Sweetwater County Assessor, and I'm also here representing the Wyoming County Assessors Association. We testified yesterday, and we are not opposed to this bill. We are kind of data-driven in our profession, so information is always good, data is always good, but we are not opposed to this legislation. Now, there was discussion yesterday, you asked our opinion on acquisition value, and we do, as assessors, have some problems with that methodology for appraisal. But as far as the bill itself, as far as doing the study, we are not against this, Mr. Chairman.
Please explain what issues you have with the acquisition model.
Well, there's a lot of issues. We did send a white paper out yesterday. Acquisition value, just to kind of clarify for everybody, means you actually value a home based on the price that it is sold for. Right now, assessors are required by the Department of Revenue and the State Board of Equalization to have your sales ratio between 95 and 105 to be in compliance with both agencies. So in that situation, we are, at least in Sweetwater County, I shoot for 96%. If I am right at that number for the values that I'm coming up with, I'm really, really happy with that. Because if the market ticks up a little bit, I've got a little room. If cost tables go up, I've got a little room. But if you go to acquisition value, you are immediately at 1. So you are valuing that property for the price it's sold for. There has been other models of this type of tax structure. California is the one that comes up a lot, Prop 13. There are a lot of issues with that. You are valuing, if Representative Nicholas and Representative Larson have 2 homes right next to each other, if one of you bought it 25 years ago, your tax basis is based on that purchase price. If it's a house on Malibu, that could be $300,000. If Representative Nicholas comes in 25 years later, that could be $13 million. And it could be the same 1,200 square foot bungalow. So in our eyes as assessors, that is not fair and equal. It causes a lot of disparity. And one of the things they found in California is it really cut tax revenue. And what the legislature was forced to do was to replace that revenue with other taxes. So I would caution you, like I said before, the study's great. We're pretty sure what you're going to find, but information is always positive. So
my question would be, if we were to broaden the language, to do a little more homework, I think you've probably heard some of the testimony that's been going on the House floor and the concerns, particularly in the Natrona County representatives. What would we look at to help find out and have better understand what's going on?
I truly believe the system we have works. I truly believe the appeal system we have works. Toronto County was an off-the-wall 100-year flood example, but I do think the system works. But if you are going to study the tax system, I would suggest you look at all three pieces of it, because you have the value part, which is the part that we seem to be all focused on at the moment. But there's also the assessment rate, which can be controlled by the legislature, and that's the 9.5% or the 11.5%. 11.5% is the factor for industrial, 9.5% is for everything other than minerals. And the legislature has control over that. Now, the other part of that as well is the mill levy. So we take market value, we take it times the assessment rate, and then we take that assessed value times the mill levy. And when that's actually what you calculate a property tax to. And there are other pieces in there that may need to be looked at as well. We keep focusing on the value, but there are two other pieces to this puzzle that need to be looked at as well.
I think the key component to having any study is to educate people. And so we can learn more about what you do and get a comfort zone. So we understand what happens and make it easier for the taxpayer. So any comments you would have on a study that you think would be useful and help educate us and the public, then why don't you just put it on a little white paper together and feed that to us, and maybe we can modify the bill a little.
We most certainly can do that.
We appreciate it. Okay, go ahead.
And, Mr. Chairman, Ken Gill, Laramie County Assessor. Again, I'll repeat what Dave said. We're not against a study. Data is always good. But in this acquisition type value becomes a very regressive tax. As you know, there was a bill earlier that was not received for introduction on changing the gross revenue for agricultural rate. And that did not get introduced. And some of the testimony on that was, well, we're going to hurt the startup ranchers. Well, acquisition cost is going to hurt the startup home buyer, the very first time they bought a home. And I'm sure there's a lot more first-time home buyers than first-time ranch buyers out there. So I kind of look at that logic that way. We will be, if we ever move to an acquisition type style, it is a very, very regressive tax.
Okay, appreciate your comments.
Absolutely.
Any other folks want to make any public comments? This is a good time to do it. Come on up. Welcome, Brenda.
Mr. Chairman, members of the committee, Brenda Henson, Director of the Department of Revenue. I just wanted to provide some clarification related to the $70,000 that is the ask for the appropriation. So as we looked at this legislation, the key components of it, first and foremost, are noted on page 1. Lines 11, where it really asks the Department of Revenue to conduct a study on the statutory, regulatory, and procedural changes necessary to convert Wyoming's property tax system to an acquisition value-based system. So in doing so, that piece, it's just an exercise of taking everything out of statute. And obviously that would include the Constitution as well, because our Constitution is not what would I call conducive to an acquisition value system, and mainly for some of the reasons that Mr. Davis mentioned about House A that just sold compared to House B that is exactly the same, but it's valued differently. So we know that there are some constitutional questions there that we would include. So that's one piece of this. The other second piece would be on page 2, related to that it would be implemented in a manner that would be revenue neutral for the first year. We're assuming that that means revenue neutral to the taxing entities, not necessarily to the taxpayers, but certainly trying to determine how that would be taken care of. I believe there was an amendment on the bill in committee on lines 7 and 8, where it talked about that the study would only focus on this changing to acquisition value for property types other than agricultural land and commercial. What that leaves then is industrial and residential. And I believe the intent of this bill was to really focus more right now, at least on the residential. When we look at the industrial, that would also have included our department assessed properties, our industries, those types of things. So it's my understanding that at this point, this is just focused on residential only. The other piece, when it talks about acquisition value, means the purchase price paid for the acquisition of property. We know we have to study the what's that mechanism for finding out what that purchase price was. In Title 34, the State Board of Equalization has a statement of consideration that's filed when properties change hands, but that's used in the appraisal analysis. It's really not the basis of a tax. So I do believe that this study would need to look at, is there a different way, a different means to collect that information, and would taxpayers actually apply for the ability to be valued based on acquisition as opposed to fair market value? And by that same discussion, are we talking about still leaving fair market value in place for all of the other properties that have not sold recently? This study, I believe, looks at all of those things, but what I recognize and why that $70,000 number is there is it's confined to only looking at what the changes would need to be using acquisition value as a basis for taxation. We would be just collecting the data, and we anticipate hiring a private consultant to do that work, to look at our statutes and basically just simply give guidance on suggested language changes that we would need. Now, in addition to the statutory, constitutional, and rules, we also know we need to look at our computer-assisted mass appraisal system that's used by all 23 county assessors. We have reached out to that vendor. They have indicated they can give us some idea of what it would take to implement such a system. Really, the crux of it would be what would we do with the other properties that didn't sell, that we don't have an acquisition value for. I really didn't have a lot of time to find out a lot of good information on what the fiscal note should be, because when I reached out to some of these companies that do contract work like this and do these types of studies, they required 30 days to give me an estimated amount that they would charge for the study itself. Well, since I didn't have that, in my own mind, I used this narrowly focused acquisition value based on the language in this bill to arrive at this $70,000 amount. And with that, we believe that it would be an informational study. We would not identify the pros nor the cons. We would simply be on a fact-finding mission for this body to make your choice. So with that, I stand for any questions, Mr. Chairman.
Representative Stitt.
Mr. Chairman, Ms. Hanson, on page 1, lines 10 and 11, it talks about the Department of Revenue shall conduct a study on the statutory, regulatory, and procedural changes necessary, et cetera. In your mind, is that language broad enough to allow you to look at estimate the lost property tax revenue that would likely occur if you froze in time the valuation to the acquisition value over, say, a 10 or 15 or 20-year period? Because it's pretty obvious that there would be a diminution of property tax. And I would think if we're going to do a study like this, you're going to want to know how much money we're going to lose.
Mr. Chairman, Representative Stitt, I do believe that based on the language on page 2, where it talks about the study shall assume that the change in valuation based on acquisition value shall not apply to those, but somewhere in there. Oh, right above that, I apologize. Right above that, it talks about the values prior to implementation of the system, and prospectively would look at what those differences would be. So I do believe that there would be an answer to that question, how credible? I'm not sure, in that we don't really have the ability to look in the future. We have the ability to look historically. So I believe in order to answer that question, we would have to look as if this statute were in place, let's say 4 years ago, compared to what fair market values have done over the past 4 years. And had we been on an acquisition value basis 4 years ago, how would those numbers have looked as far as difference? So I hope that we would answer.
So Brenda, just in generalities though, is $70,000 going to be remotely enough to hire a consultant? I mean, we don't hire any consultants for that less basically around here. That little, I should say.
I realize staff at the Department of Revenue would be assisting wherever we could, as far as providing them direction, as far as providing them information from the CAMA system. So it will take some staff time, and I believe, again, since they are not going to be required to do any analysis of whether it's a good idea or a bad idea, I'm hoping that we can get a study for that amount. Now, if we broaden that scope, I definitely think that cost would be significantly more. And I think, perhaps we would go to, I mean, it has been studied historically by this body. We go back to those prior studies, even back to tax reform 2000. Definitely, these are not new concepts.
What states use the acquisition value?
At this point, of course, the one that most people are aware of is California, and they've actually been on that tax structure for over 40 years. But it's very well documented what the impact of that was. And so we've got that information. There might be one other one, and I apologize, I've not done that research.
So that's my next question. This is Prop 16, right? Essentially.
13.
13, that's right. Yeah. And that's what that's what you understand acquisition value means.
Mr. Chairman, I do believe that is the closest structure, tax structure out there that is an acquisition value. But when you go into the statutes, you're going to find all kinds of variations of acquisition value and what those bases, what rules did they put in place as to when that trigger pulls that you aren't on acquisition value anymore. And so I guess I'm just cautioning that even though, yes, that system is an acquisition value system, they still have the rest of the properties to value as well. And how is that done? And so I think that there's going to be more investigation, but I'm not going to say that we're going to get answers to everything. I think what we might find out is there are no answers to some of the questions that we may have on implementing an acquisition value system, but it's
Okay.
information.
So I think we need to kind of cut off discussion because we're going way beyond a re-referral, but the education is nice. We appreciate it. Any other quick comments before we kick this bill out? You've helped us a lot. We appreciate your assistance. Okay, we'll close public comment. Representative Schwartz.
Yes, Mr. Chairman, I have a procedural question. So we've got the bill and then we've got the standing committee amendment, which has the appropriation. So my assumption is in the re-referral, we can amend that standing committee.
Yeah,
amendment.
we're supposed to.
Yep, I'm just making sure, because I would have an amendment when it's appropriate.
Please proceed.
Thank you, Mr. Chairman. On the amendment, standing committee number 1 on line 13, 12 and 13, I would change $70,000 to $0.
Is there a second? Moved and second, discussion.
Thank you, Mr. Chairman. So I look at this, it's a very narrow bill calling for a narrow study with certain assumptions in that study.
Okay.
And I'm all for looking into this topic, but I think if we're going to do it, we want to do it without assumptions and in a much broader capacity. So I think it's probably better as an interim topic than as a bill with an arrow study. So hence, I would like to take the appropriation.
Senator Larson.
So, Mr. Chairman, and the concern I have with that is then if the bill passes, we've saddled the agency to do this study without any resources to do it.
And we give them 1 week to do it.
Mr. Chairman, Vice Chairman, I appreciate your concern. I guess I'm going to leave the motion out there, and if it goes down, so be it.
And Mr. Chair, I appreciate that. I just wanted to have that conversation.
Okay, further discussion on the amendment. Oh, go ahead, Reverend Stiff. You're going to say something? Looked like you're about
No,
to.
Mr. Chairman, let's just vote.
Okay, all those in favor of the amendment, say aye.
Aye.
Those opposed?
No.
Show of hands. All those in favor, raise your hand. All those opposed? That motion fails. Back on the bill. Move what though? Do pass or? It's do pass motion. Any further discussion? Seeing none. Roll call, please.
Representative Kinner,
Aye.
Representative Larson,
Aye.
Representative Schwartz, Representative Simpson,
No.
Representative Stith,
No.
Representative Walters, Chairman Nicholas.
No.
Mary Lee? I changed mine to no.
Okay,
Okay, so that is all no's.
that's a surprise. Okay, any other re-referrals? 66. This is the ARPA bill. Public comment. Any public comment? Come on up. Let's go. If anyone's going to go. All right, seeing no public comment, we will close public comment. Motion on the bill. Move do pass by Representative Walters, second by Representative Kinner. Discussion.
Mr. Chairman, we're doing a roll call vote on this.
This is our bill.
Great.
Right.
Mr. Chairman,
Go ahead.
I do have an amendment. If Mary Lee could pass it out. It's technical in nature and it relates to
Want this one?
you don't have it.
What's the number on the amendment?
Oh, let me look on my computer. Excuse me, Mr. Chairman, I'm on the wrong bill. Mine is on the Capcom bill. My mistake.
That's what
I got
I,
ahead of myself.
that's what I thought.
Mr. Chairman,
Go ahead.
I have a proposed amendment that I believe has been distributed. And essentially it reads on page 12, line 20. After the word service, to insert the Wyoming Business Council is authorized and directed to include performance requirements in its contracts with grant recipients, which performance requirements shall at a minimum require the grant recipient and any successor in interest to offer and provide continuous service to broadband customers during at least the first 7 years after substantial completion of the relevant project for which grant funds were expended. If I can get a second, I can.
Go ahead.
So, Mr. Chairman, during the first round of broadband funding in the CARES Act, The Business Council did a great job of getting projects done very quickly, but the timeline was so short. There were, my understanding is the carriers only had 77 days to get their project approved and started and completed, I guess. So it was very quick. As a result, those contracts tended not to have any performance requirements. That is, and what we want to, and I think the carriers are in good faith building out the system and providing service. But if we're going to be spending millions and millions of taxpayer dollars on building out broadband, then it makes sense to me that they not just build the infrastructure, but that the broadband carriers actually provide service. So what I want to avoid is the situation that happened in the 1970s when the administration then, the federal government, gave a lot of taxpayer money to utilities to build wind turbines, but did not require that the wind turbines actually produce electricity, resulting in the 1970s of these wind farms that got built and then were not used. So that's a long-winded explanation of just saying we give the authority to and direction to the relevant agency to put that in their contracts.
Thank you, Mr. Chairman. It's really a question. So 7 years because what?
Mr. Chairman, the choice of it, the phrase is that the provider would be obligated to provide continuous service to customers during at least the first 7 years. This would give the agency, if it wanted to, the ability to put in a longer term, 8, 10, 15, 20, whatever it could negotiate if it deemed necessary. But 7 years would, you can imagine a situation where they build a line to a very remote area at great expense, and there's only 2 customers on it. And so the carrier loses money every month on that project. And if they take a lot of money, they can lose money for 7 years, but it might be onerous to require them to. But that number is to some extent arbitrary. If the committee wanted to make it a longer term, that's fine with me.
On the amendment. All those in favor say aye.
Aye.
Those opposed? No. That motion carried. Okay, so I have an amendment. I have 2 amendments. I got to find them here. Between this and my sandwich, I'm getting lost. So this is written as a, no, it's just an add. Distribute the technical one. Where's the line? It's written as an amendment to as a budget. Okay, I'm passing out the amendment for everyone to look at. Page 15, line. Oh, and yeah, 2 components to it. Basically, what this does, just for a simple explanation, this is based on discussions with the co-chair and I, with the good folks at the Wyoming Supreme Court, adding 3 different items that were listed on that on the ARPA spreadsheet that was part of the study. And one is a case management system, a triage portal, and a website update, and the remote interpretation for use for all trial courts. And it's a combined total of $817,000. So that's what you see on page 5 after line 10. Inserts that 817,900. And then the specifics for it are listed at page 15 after line 9, number 28.
Second.
Moved and seconded. All those, any further discussion? Go ahead.
Mr. Chairman, I speak in support of the amendment as much as I dislike subsidizing my competition. I have seen in the emergency rental assistance program where their legal aid has been available for for tenants and landlord-tenant disputes. And I'm typically on the side of the landlords, and it actually has made a significant difference. So when someone has a lawyer, it does make a difference. And often people are too poor and don't have a lawyer and get the short end of the stick. So I'm in support.
And I don't disagree with that, but these don't really help your competition. Okay, all those in favor say aye.
Aye.
Those opposed, that motion carries. And I have a technical correction. Has that been passed out? You want to move it?
Chairman, I move proposed amendment number 802 to this proposed Senate File 66.
All those in favor say aye. Those opposed, that motion carries. Any other amendments? Seeing none. As amended, all those in favor, roll call.
Representative Kinner.
Aye.
Representative Larson.
Aye.
Okay. Representative Schwartz.
Aye.
Representative Simpson.
Aye.
Representative Stith.
Aye.
Representative Walters.
Aye.
Chairman Nicholas.
Aye.
All ayes.
Mary Lee, before we completely leave that, would you go back? When we, last time, we talked about deleting on page 13, starting on line 4, the new sentence starting with matching. And then come down to Roman and I through. Did we do that?
Yes, sir, we did. That was, yes, that is taking, it passed.
Okay.
We voted on it. We've got 6 or 7 amendments to this,
Okay,
what you just did today.
just trying to tie them together. Thank you, Mr. Chairman.
Okay.
Okay,
Roll call.
roll call. As amended.
On SF 66, do pass as amended, were all ayes. We just did roll call. Okay, okay.
We're hitting on all cylinders.
You're batting 1,000. Yeah.
What do you want to take?
I don't know which one you want. So did we already vote on it? So we voted on 66 already. And let's do it again because as amended, just to be safe.
All right, so the vote is on SF 66, do pass as amended. Representative Kinner,
Aye.
Representative Larson,
Aye.
Representative Schwartz, Representative Simpson,
Aye.
Representative Stith,
Deja vu. Aye.
Representative Walters, Chairman Nicholas,
Aye.
all ayes.
All right, have we decided who's gonna be the floor manager for this bill?
It's only $360 million. So
Think about it.
Might divide it up.
Yeah, okay. All right, what's next? We have a
67 or 2?
Capcom, let's do that. We got a few folks here for that.
67.
Okay, public comment on Capcom bill. This is your chance. Speak your piece for.
What are you doing?
Try not to get me indigestion while I'm eating.
Mr. Chairman, John McKinley, UW Board of Trustees. Just wanted to take a minute and visit regarding a couple items in Capcom Bill 067, page 12, lines 5 and lines 9 and 10. So as you know, and you've received materials, there are 3 capital construction projects. The law school project, which is budgeted at approximately $30 million. The natatorium and West Stands projects total approximately 100 million together. So you have 130 million of construction projects. The way footnote 1 is drafted, starting on page 12, line 9, requires a dollar for dollar match with a $50 million appropriation. And the match can come from any source, and we can deal with that, but that only provides $100 million of funding for $130 million total cost for those projects. What that does, that either results in one project or not being done, or the funding of that additional 30 million has to come out of other UW funds, because the testimony you received earlier in January from Tom Berman and Clint Alexander at the law school is the private fundraising was probably going to be limited to approximately 20 million for the West Stands pool project, possibly 25 million, and approximately 5 million for the law school. So
2 to 1 works better. 1 to 2.
well, if the 50 million was 65, that's a 1-for-1 that gets you 130. If it's 60, then it's 120, and UW has to find another 10 that's not matched. At 50, we have to find another 30 that's not matched, because the delta is 30 million, and so we don't have a match on that. These are very long-term projects, 50+ year projects. It's an investment for the state. I would encourage some consideration and thought on changing the 50 million to 65. Stand for questions. Mr. Chairman, Representative Swartz, I'm sure there are somewheres, but that does not cover the delta of 30 million.
Mr. Chairman,
Go ahead.
your explanation is accurate under the assumption that you do all 3 projects. This language also said you could do any combination of or drop a project. And so I think that's the other thing to consider, is dropping a project, and we could fund it in future years.
Mr. Chairman, Representative Walters, that's the implication in the footnote language is, but the only project, I'm going to be really blunt, the only project that is almost shovel ready is the law school project. The other 2 projects are still in the early design drawing stage. Likely, those projects wouldn't proceed until calendar year 2023. A nuance that comes into play is the Board of Trustees pursuant to UW regulation, the Board of Trustees can't approve a project to proceed until full funding is in place. We don't do any of these construction projects on the come. We wait until full funding is in place to do them, and it makes it difficult to do it otherwise. So that's the explanation, Representative Walters.
So the question is, if we appropriate 50 million so that we have money in hand, and if you do just the west stands and the lost, and then come back next year and ask for money for an auditorium so that we can deal with our friends down the hall and kind of do it incrementally. Assuming that we can come up with 15 or 20 million next year to match, another 15 from you, then that might bring your cost down as opposed to trying to wrestle them all together, three into one.
Mr. Chairman, it may bring the cost down, but with the increasing cost of construction costs, it's probably a net zero on that issue. The other issue of concern and why the West Stands and the auditorium are a combined project is the fundraising, as this body knows, the fundraising solely for the pool has been very difficult in the past. Look back the last 10, 15 years, unable to raise private funds for that. That's why those two construction projects were coupled together for private fundraising purposes.
Mr. Chairman,
Go ahead, Representative Kinner.
thank you. John, could you remind me, I do understand the reason to keep the two projects together. I do understand that. But if you were to separate them, what would the numbers look like if you were to take that whole amount and break it into two parts?
Mr. Chairman, Representative Kenner, I'm doing this from memory, so it could be a little off, but my recollection is the pool project by itself is around 35, 40 million. And the West Stands project, which is the lower West Stands, and redoing the boxes upstairs where the TV crews are, elevator, a couple of concessions, bathroom. That's the West Stands project, is approximately 65 to 70 million in that range for a total of those two of 100.
Okay, thank you.
Go ahead.
John, I hear you. I really do. And so, but I guess the point that I'd like you to consider is when we started this several years ago, we now have this bird in hand that's at 50 million, which is considerably more than we have asked before. There's something about that horse you look in the mouth. And I just have to tell you that in the county I come from, the biggest angst they have is when is enough enough, and I'm trying to be really, but so I just tell you from the world that I live in, and I know that these costs have gone up, and I know that, but I think that we are wise to move forward and do the best we can. We realize that there may be some things that impede our ability to do everything that we might have to address later. But I think there is so much more in this bill than the University of Wyoming. And that all gets put at risk. Is all I'd have you consider.
So, Mr. Chairman, Representative Larson, I'm tracking you 100%. I happen to be from a county further west than your county.
Over the hill.
And I understand the concern and I understand the benefit of the bird in the hand and not looking that gift horse directly in the eye. I just wanted to make sure everybody understood where we were on this, because there likely will be delays on a project or a project not happening with this dollar amount. Definitely don't want to jeopardize the
Well,
67. And so I understand that. But also, you know, we may or may not be back at some time in the future for funding, just depending on how things shake out.
And then just follow up, Mr. Chairman, and I think the one thing that I really do appreciate and appreciate the frankness on is that the natatorium and the west side stands is still going through some design phase. And so that does give us some time to consider and probably more accurately reflect what the inflation will be, because we're just making estimated costs now, right?
Mr. Chairman, Representative Larson, we're estimated costs on the west stands and natatorium. We're pretty hard costs on the law school. We've had
No, right,
we've had
right.
good numbers on that.
I think that's right. I think we know what the law school is, Mr. Chairman, but I'm saying, so we've still got some design to do on those other two. And so I don't think it surprises anybody as those come back. Once you get into design for construction, that numbers may reflect something than what we have in place.
So, Mr. Chairman, one thing we could do if the projects are authorized, but maybe not fully funded by this body, UW has in the past and could authorize expenditure of funds for the design and the construction document phase on the two projects, the natatorium and the west stands, proceeding construction on one, but also having more fully developed documents. The problem is those get outdated fairly rapidly, and so it's kind of a sunk cost once we do it, Mr. Chairman.
Mr. Chairman.
Go ahead.
Thank you, Mr. Chairman. John, I understand the heavy lift that the university has taken on for the dorms, the bonding and so on. Is there any additional room that could be maybe used along those lines of bonding of some sort, revenues, some sort? Just curious.
Mr. Chairman, Representative Kenner, that the terms of the public bond issuance for the dorms were such that it has to be used for dorms and related facilities. At one time, we considered trying to figure out if the natatorium could be part of a recreation facility for the dorms. It really doesn't fit. In addition, because of construction costs and the requirement to do approximately 2,000 beds, and we're doing 1,900 and some in this first phase on the dorms, we're kind of tapped out on where we are on the funding for that with the parking and the dorms.
Mr. Chairman, follow up. Thank you. So I didn't mean sort of fold it into the dorm project. I guess I was wondering if you had additional capacity that you could use to bond one of these projects.
Mr. Chairman, Representative Kenner, my short answer is no, I don't think so. And that's just, I'm doing it from memory. We have some bonds that are coming out of the cycle being paid, but it doesn't free up enough over time to get these done.
Okay, thank you.
Representative.
Mr. Chairman, so recognizing that pigs get fat and hogs get slaughtered, would it be more honest to delete the reference to the natatorium because there just isn't going to be enough money to pay for it.
Mr. Chairman, Representative Stith, depends on the temperament of this body on whether they want to make the decision on the construction projects or leave that to the university and the Board of Trustees. Having the flexibility on 3 also provides some flexibility because the natatorium is included, that we could use funds to do the design and construction documents. So I think it's beneficial for everybody that all 3 projects are included.
Representative Simpson.
Mr. Chairman, to bring this to a head so we can move on. I think that we are in a sensitive place. We've been able to persuade as a joint appropriations committee, the other body to go with the $50 million figure. I think we're wise to stay exactly on that course. I am privy that there are members of the House that are planning to bring amendments to the floor individually to assist with additional dollars. I think that's the appropriate way to go so that we don't compromise our negotiations with the other chamber.
Further comments? So it would seem to me that at any rate, a minimum, what we need to do is modify the one-to-one and make it a different number. Whether it like, so for every $2, they have to contribute 1. That's the only way they're going to get to 130 million on authorization, because they can only spend up to 100.
For every dollar we put in, they have to raise 2.
Other way around. For every $2 we put in, they have to raise.
Excuse me, we don't need to do that. We had this discussion earlier in the month when the joint committee passed this out, and I asked this very question. We don't authorize total maximum allowable like we do for the community college situation. So this 50 million goes into basically a capital construction block grant for the university, and they could spend 300 million on these projects if they raise that much. We do not determine their maximum allowable expenditure on projects. So whether it's at 1-to-1 or 2-to-1, they can still get to the 130 million necessary. We're just saying on this particular 50 million, it's 1-to-1. If they raise an additional 30, 40, 50 million, they can do that without our blessing, and we applaud their efforts if they can get that high.
Okay. Any comments on that?
Mr. Chairman, Representative Walters, if I'm understanding the explanation correctly, page 12, lines 13 through 16. Authorize, in the footnote, authorize the expenditure of the appropriation conditioned on the match of 1-to-1. That would get you to 100 million. There's nothing that, if I'm understanding the explanation, there's nothing that would restrict us from spending 105 or 120 or 130 million with that explanation.
Mr. Chairman, that is correct.
Okay.
Thank you very
Thank
much.
you. Appreciate it. So Mike, before you go, if we authorize this, will you be able to get final documents and start breaking ground for the law school this summer? If we make it effective immediately?
Mr. Chairman, I did not look at the effective date of this, but I think it's July 1. And the construction documents are close to being finalized, I think, for the law school. So, and there's approximately 5 million of private funding that has been raised. So assuming that the administration and the trustees decided that the law school project should proceed with this funding, we should be able to break ground this fall.
So is there an advantage to expediting it so that you can break ground as soon as people are out of class. In other words, I mean, I can put that in the bill. if I need to.
Mr. Chairman, the regulation does not allow us to approve a project until full funding is in place. And so this funding, if I'm understanding it correctly, the earliest it would be in place would be July 2nd.
So, Mr. Chairman, I think what you were asking is we could make that effective immediately as soon as it's signed. Then it would be funded.
And if it was effective immediately upon all acts necessary, then assuming that it was approved by the administration and the trustees, full funding would be in place for the law school, probably by green grass.
That's,
Mr.
and
Chairman,
yeah, go ahead.
if it was still July 1, but signed by the, if the bill was signed by the governor, even within a July 1 effective date, I don't think effective immediately or effective July 1 would really affect the ability for you guys to get your plans together and proceed. I don't think you could have a contractor in place and ready to go before August or September, to where you could be proceeding as soon as the governor signed this, knowing the money becomes available July 1. That's once it's signed, it's available essentially without effective immediate or not. I think the timing issue becomes how quickly are the plans going to be ready? How quickly can you get a contract, start talking to contractors? I just don't know that we need to be effective immediate if you know the bill has been signed and when the funds will be released. Any further thoughts on that?
Mr. Chairman, Representative Walters, I agree conceptually with that, but UW regulation does not allow the construction project to be approved or proceed until full funding is in place. And so we can do some preliminary things, which we've done with the law school. We've authorized expenditures for plans, construction documents, that sort of thing. And the trustees' in-person board meeting is in May. It's a phone meeting in June. It's an in-person meeting in July. It's probably once a project of this magnitude would be approved, you're probably looking at 2 months, 3 months to get a contractor under contract and everything else. Then they have to mobilize. So you have another month. That's why I was thinking May, you can have somebody, by fall. That's the timing issue.
Okay, further questions for John? Appreciate it. Any other public comment?
Thank you, Mr. Chair.
Come on up, Darren.
Thank you, Mr. Chairman. Committee, Darren Westby, Director of State Parks and Cultural Resources. I just wanted to kind of get you up to speed on what transpired over in the Senate with that transpired after this came out of the joint, the Capcom bill out of the joint committee. What the Senate did was granted the agency the authority to purchase the State Trails building just south of Lander. The building we found about 5 years ago that the building might have been going up for sale. And so about 3 years ago, we started really working towards getting the opportunity to purchase that building. The State Trails Advisory Board started working with their associations to see if they could use their registration fees to save up enough money to have the ability to purchase this building. And so on page 2, there's some description starting on page 1, going into page 2, granting the authority to utilize the building. And then on page 14 and 15 is the authorization to purchase the building in the name of the state of Wyoming. And with that, I know that there might be an amendment coming. The way the original language was read on page 2 talked about the rental income would all come back to the State Trails Program. However, A&I department would be managing and operating the building, and there's some obvious expenses in maintaining and operating that building. And so we worked with the A&I department to craft a potential draft language to have the ability for A&I to operate the building, utilize some of the existing tenant revenue that's in there, which we have 2 other tenants that are in that same building. Department of Transportation has a small section in there for their driver's license area. And then also the federal courts has a section in there as well, utilizing the revenue off those rental income on those 2 renters to help offset the cost to operate and maintain that facility. And I know we have representatives from A&I if there's some questions on that, but with that, Mr. Chairman, trying to be brief, but informative, I would stand for any questions you might have on the building.
And you said that there was a tentative amendment to address that, or is it just going to be an MOU between you and A&I?
Mr. Chairman, I think there would need to be an amendment because as it reads right now is all the revenue comes back to us. However, A&I has the requirement to maintain it.
So who's putting together the amendment? Is it done? Okay, so we're going to do it today. Okay, that makes sense.
Thank you, Mr.
All
Chairman.
right, anything else? Representative Stiff.
Mr. Chairman, Mr. Westby, thank you. With respect to the property management fee, essentially that A&I would be charging, any sense for what percentage that might be of the rental income? It's going to be 20%, 50%, 100%. I mean, will there be any money left over once the property management fee gets taken out?
Thank you, Mr. Chairman, Representative. Right off the top of our head, I think the 2 renters in that facility outside of us, I believe their rental income is over $100,000 a year. And we're relatively confident, and I don't want to speak on behalf of A&I, but we're pretty confident that that $100,000 a year would be more than enough to cover the expenses. And anything, and the way I think we're working the amendment, anything over anything that's not expended on the operation and maintenance of the facility would tip back to the snowmobile and ORV.
That's not cheap. Go ahead, Representative Schwartz.
Who's the other tenant? Why not?
Mr. Chairman, Representative, it's the U.S. courts. They have I believe a magistrate court facility there.
I hope you charge the federal courts more than you're charging.
Mr. Chairman, I think Section 9 of the A&I's laws dictate what and how they have to go about that as well.
Okay, appreciate your comments.
Thank you.
Any other public comments? No. Okay, we'll close public comment. Moved by Representative Walters, seconded by Representative Larson. Any amendments to the bill?
Mr. Chairman,
Go ahead.
if I could ask for help from Mary Lee. I do have an amendment. And while she's passing that, I'll give you the backstory. So if you recall, in January, Senator Kinski and I proposed some wording changes so that this project could include remodeling and landscaping and so on. And so that amendment was approved, by the way. Well, after taking a look at the language and really diving into it, we realized that in order to use the donated property as a match, we needed to change the language. And so that's really all we're trying to do here, is give the college the opportunity to use the donated property as a match and go ahead and get started on the project. And so I would ask, I would move that and then ask for a second. So that's it in a nutshell. I'll be happy to try to answer any questions.
Questions? Seeing none, all those in favor say aye.
Aye.
Those opposed, that motion carries. Any other amendments? Tom?
I do have one, Mr. Chairman, and Mary Lee will pass it out, but I can tell you where it is. It's on page 2, line 9. after the word paragraph, we will be inserting the sentence or words that exceed the expenses needed for the operation and maintenance of the facility. And then the sentence will continue, shall be deposited quarterly.
There a second?
Second.
Second by Representative Larson. Discussion.
Mr. Chairman, this just addresses what the good director was speaking of. And so this allows for state parks to use their rental income to maintain their building. And then after they have maintained their building, they will make the deposit quarterly in equal amounts to the snowmobile trails account and the ORV trails account. And this eliminates the need for A&I to use general fund dollars to maintain this property.
Okay, all those in favor say aye. Those opposed, that motion carries. Any other amendments? Okay, I've got a couple.
Really?
Page 2 and 3 on the capital square preservation account. At the end of that, apparently I have that effective immediately. All those in favor say aye.
Aye.
Those opposed, that motion carries. Then going to the, I want to add $250,000 on section 27 on page 7. And then we'll add a one more section on the back. Right. The other page would be a descriptive footnote. And so we'll have to, it'll be a, let's see if there's a place to put it. Actually, the place to put it would probably be in this capital square preservation account. So I want to add a line, and we'll work on the language, but says appropriate an additional $250,000 for the development and construction of a display of the Wyoming Constitution in the Wyoming Capitol.
Okay, let's do that again.
Okay,
Okay,
so have a peek at it and see if you think it fits there. But under the 94225 capital square preservation account, we'll add a section that directs $250,000 for the planning and development of a display of the Wyoming Constitution within the Wyoming State Capitol.
So, Mr. Chairman, then does that mean that's what that money has to do?
Yep.
Why do we want to do that?
Why wouldn't we want to do that is the question.
I don't know.
So, I mean, the concept is, you know, I just learned that our Constitution is sitting in a warehouse under the original. And it's in a kind of almost like a chief tablet form. And so the concept is to either have the original or a replica of the original made, put it under glass, someplace, and it's going to have to be probably climate controlled and whatever else we need to do. But have the display designed and constructed for either the original or the replica. So when people come into this building, they can hopefully they'll walk into the territorial part of the Capitol where it was signed and have a display of the Wyoming Constitution like that. And then as part of the wayfinding, we'll develop whatever we need to do for, you know, like a talking display, if you want to hit a button and that kind of thing, and then where and whom and how and who signed it. But it makes no sense to me. We are not using and having our Constitution on display for people to see. And it's just sitting in a warehouse. And it'll be a draw, I think, for more folks and for more school kids to come. And it'll be an educational tool that otherwise it'll never happen. So.
And Mr. Chairman, thank you for the explanation. So let's imagine we get a bargain and it's costs $107,000 to do it all. Where does the difference go? Does it revert? What would happen by default?
It would stay in the wayfinding.
Mr. Chairman.
You want to make it 500,000?
Mr. Chairman,
Go ahead.
I think your conceptual amendment is quite fine. On page 14, in section 4 at the top of the page is probably the appropriate section.
Yeah,
And we would just make like a Romanet A or something there. And that would be where we would put in 250,000 for the display of the Constitution.
I agree. That's probably a better. place.
So just, and I'm not disagreeing with the amendment, just, or
Yeah.
just functionality of where it should be located.
That's why I asked. Okay, on the conceptual amendment, all those in favor say aye. Aye. Those opposed, that motion carries. And we'll amend as necessary, fix it. And so before we kick it out, we'll bring it back and we'll make sure that it's accurate.
Definitely.
Okay, then one more amendment. Going to the University of Wyoming, page 12. I want to put in a provision that says the funds for the construction of the law school will be effective immediately. No, I want to use the name. Because that puts it on first. on the list. Okay,
Mr. Chairman, so are we designating an amount that's effective immediately? Is it
No.
all? We're just,
no. Just funds necessary to construct the law school will be effective immediately. So they know that they have it now.
so Mr. Chairman,
So
when,
if they want to hold a special meeting in March or
Mr. Chairman.
February, they could probably do it.
does that create an issue for our budget officer? Because they try to create the profile and they allocate by fiscal years on our goldenrod what funds are in this fiscal year and what funds are in next fiscal year. Do we create a problem for them by
don't
not telling
believe
them
so.
how much it is?
Okay, everyone understand the amendment? All those in favor say aye. Those opposed, that motion carries. Any other amendments? And we'll review those before we kick this out. Okay, as amended. Roll call.
So Senate File 67 do pass as amended. Representative Kinner.
Aye.
Representative Larson. Representative Schwartz. Representative Simpson.
Aye.
Representative Stith.
Aye.
Representative Walters. Chairman Nicholas.
Aye.
All ayes.
Okay.
Sir, I will hunt him down.
You just turn your head. All right, thanks, John. Okay, let's move on to the feed bill. And Matt, you want to walk us through this?
Mr. Chairman, members of the House Appropriations Committee, Matt Obrecht, LSO. Before you today is Senate File 2 engrossed, the legislative budget.
Is it just me or is your voice a little deeper today?
It's a little deeper today, Mr. Chairman. Stopped off for some cough drops.
Have you been practicing?
So, yeah. Trying to get to, yeah. So, Mr. Chairman, bill starts in section 1, page 1, with the biennial appropriations to the legislative branch. Page 1, line 15 is LSO permanent and temporary staff salaries, legislator session salaries, interim salaries for legislators, session staff, and employer paid benefits. On page 2 now, we've got in-state travel, out-of-state travel, our dues to NCSL, Energy Council, and CSG, registration fees, telecommunications costs, our network costs to ETS. On top of page 3, our general admin support costs. These are all of our IT copying. This includes, we're up on the 4-year cycle for everyone's going to get a new laptop or Surface this year, legislators and staff. Mr. Chairman, we're going to renegotiate our contract this year, let it out, or actually let a contract bid it for our statutes. So it's time to do that again. And that's going to be a changing landscape due to a Supreme Court decision on how the publishers of those can charge for their annotations. So I don't know how that will impact the contract we have moving forward with whoever receives that bid. But we've included money for that if we need to pay for our statute books. The total appropriation for the biennial expenses of the government, or I'm sorry, legislative branch.
Matt, on our staff and permanent temporary, does that include, as we've talked about, pay increases for state employees? Does that incorporate anything in there?
Yeah, Mr. Chairman, that includes pay increases for legislative staff.
Thank you.
So if the House side prevails that we just passed yesterday, does it include that?
Mr. Chairman, there would be enough room within the legislative budget if Management Council wanted to do a like increase for legislative branch employees, they could.
Thank you. Go ahead.
Matt, on the page 3, line 7, statute, session laws and digests, how many sets of all of that get created? Because, and what's the per set price?
So, Mr. Chairman.
One for me.
And Representative Stith, I think we're at about, about 650 to 700 sets of statute books per printing that we pay for. And that we pay for, these are for all government entities within the state. But right now, Mr. Chairman, because of the royalty agreement we have with our publisher, we don't pay anything for those statutes. They keep some of the royalty payments that they get for their use of their annotations to the statutes. And that practice has been called into question by a U.S. Supreme Court decision that came out of Georgia. So that's why we've included these monies for the possibility that we may have to pay for our session laws or pay for our statutes this time.
Okay, go ahead.
Mr. Chairman, the rest of the bill deals with directives for Management Council on the use of these funds and also funds that are effective immediately. Section 2 on page 3 is Management Council flex. They can flex, have total flex authority among any line item in the bill. Section 3 authorizes the reimbursement for out-of-state travel to legislators consistent with Management Council policy. Section 4 is a carryover of prior appropriations. Starting on page 4, line 7, that is the carryover of our education consultant funds. This was an amendment in the Senate. The total amount of this carryover had been 1.4, just shy of 1.5 million. The Senate inserted the carryover no more than $800,000 of those funds. Mr. Chairman, the rationale given was transparency, have a number in the bill to let everyone know how much, and that is the amount we spent on the last biennial on consultants. Roughly.
So do we have a copy of that amendment? Is it? Yeah. Go ahead.
Mr. Chairman, page 5, top of it, carryover of any funds we have from the sale of legislative laptop computers back to members. And Paragraph 3 is the rollover of any funds we have remaining from the last legislative budget bill passed in 2020. Section 5 is $125,000 for us to continue work on our legislative management system and other legislative IT projects. Section 6 is $34,000 to pay for new legislator training before the new legislators are actually sworn in. So there's a separate
How
appropriation.
many days, Matt, Mr. Chairman, how many days can you do that?
So, Mr. Chairman, Representative Larson, that'll be 2.5 to 3 days. And then that's, prior to the general session, Mr. Chairman, and of course, then there'll be another 1.5 to 2 days before the budget session. Mr. Chairman, page 7, section 7 is another reappropriation of funds. This is an appropriation that was originally made to the Attorney General's office in the 2020 budget bill for their school litigation section. And we're just sweeping those funds to LSO. We've done this for 20 years now since the school finance litigation cases to be our war chest for if any potential litigation that should arise around the school foundation model.
Chairman. So again, the Senate added this not to exceed language of $1,009,000, excuse me, $1,009,000. Anything that sweeps above that just sweeps back to the general fund?
That's correct, Mr. Chairman, but Mr. Chairman, Representative Walters, there's no fear of that because that $1,009,000 number was from what was left in the account in January, and the Attorney General's office continues to utilize these funds. So it'll be something substantially less than this when these roll over on July 1.
Mr. Chair, but just clarification, it's not general fund, school foundation program.
You're correct. My mistake.
And actually, I'd prefer it for the general fund. But that's another conversation.
Okay, go ahead.
Mr. Chairman, section 8 on page 8 is $500,000 for management council contingency. Section 9 has no funds, but it authorizes out of state and international travel for legislators for economic development activities in conjunction with the executive branch. Section 10 on page.
There's no money in that?
There's no money, Mr. Chairman, but management council, when they authorize that, uses
500.
or out of money that's appropriated for legislator travel, either one. Section 10 on page 10 is $20,000 for members to attend the State Treasurer's Investment Conference. Section 11 is our facilities appropriation. $50,000 to continue Rosalie Ruart's contract to provide furniture consulting and interior design in the Capitol for the legislative branch and for the executive branch. On page 11, line 16 is $140,000 for miscellaneous furnishings and projects in the Capitol complex.
Where'd that number come from?
Mr. Chairman, that number came from Wendy Madsen, the LSO project, special projects manager, and I think in consultation with you and some others on what some needs are that remain.
Should we raise it?
That's where you ought to put that 250
So it's our constitution.
for the Constitution.
All right, go ahead.
Mr. Chairman, then there's a $12,000 fee for, that's what we think we'll need to finish up the room management professional fees. And Mr. Chairman, the last appropriation in the bill is $25,000 to pay the legislative member's salary, mileage, and per diem for the work on the Capitol Interpretive Exhibits and Wayfinding Subcommittee created in the Capcom bill last year, which I forgot to put an appropriation in that for that. So we've just been using contingency to pay for those. That's Senate File 2, Mr. Chairman.
Questions? Public comment? We'll close public comment. Moved by Larson, seconded by Walters. Roll call. As amended.
Wait a minute, what do you mean as amended?
Yeah, we're already.
So are you with me now? Okay. So do pass on Senate File 2, Representative Kinner,
Aye.
Representative Larson,
Aye.
Representative Schwartz, Representative Simpson,
Aye.
Representative Stith,
Aye.
Representative Walters, Chairman Nicholas.
Aye.
All ayes.
In the morning, got bills,
Okay.
then we'll break and go.
I hate to make you talk, but what bill did he say you?
They're just ones they
guy
carry.
who came on, was that 67? Okay, I will sort, and then if I have any questions, I'll just email you so you don't have to talk. There's lots of conflicts. Okay, good. Okay,
What that amendment is, there's existing language, just make that existing language a subsection, and we create a subsection with a 250,000.
and let's see, you said put it, so create a section 4.
No, there's an existing section.
Oh, there is. Wait a minute, wait a minute, wait a minute.
Yep, right there.
Right there, plug it in there.
Yeah, make this A, put an A in there,
Okay,
and then make a subsection B with that new language.
all right, and I'll just futz with that language. Let me send it to you for the.
Yeah, that's.
Sorry, we're.